Hi everyone, this is Captain Jade again, talking to you regarding the student loan remedy, which we had discussed not too long ago, and I appreciate everybody trying to endeavor to resolve their student loans by first picking up a debt validation and then moving on to the novation and settlement. And as you know, we have that on the creoharmony.blogspot.com. But I wanted the younger generations to start to formulate their own documentation and their mindsets about how they would resolve a situation without having templates. So the first and foremost is today I'm going to be discussing about the debt validation letter. But before we get into that, I wanted to show you a trust related to an education loan. So this trust happens to be called the Education Management Corporation. Its jurisdiction is in Pennsylvania. This is a 10K report, which means an annual report with the Securities and Exchange, which is at sec.gov. Not all student loans will have a 10K, 8K, 424B5 prospectus because they're stopped to report those in most cases, like the Discovers, the Citibanks, and so forth. But just to prove to you, and by the way, this is the SIC number, commission file number. They call that the CIK number. That identifies this, and this name identifies this whole trust. And that's what we want to find out. And to prove to you that this is a government style Department of Education, I had that somewhere. Do you see here? That's the U.S. Department of Education. If you scroll down on the 10K report, you will see the schools that are involved with this trust all around the United States. All around. This one happens to look a lot like the art institutes, post-secondary education and things like that. So these guys are all lumped into one REMIC, which is very interesting. There's other universities here, and many things you can find out about the parties involved, the trustees involved, who they're collecting on behalf of, etc. Okay, now we're going to go right into the letter, which at the top has your name and authorized representative and the respondent debt collector. I want to send this to the chief financial officer and the legal name of the debt collector firm. Now, how you find that out is you need to go to Secretary of State's website and scroll down, select either corporation or limited liability company, and search. So once you find the company that you want that's active, and then you go to this is the legal name, this is the address where they're located, and this is their registered agent's address. You don't need that for now, but you need the corporate address. So do always use the legal name of the company that you're dealing with and the attorney law office that you're dealing with. You can send this via certified or registered mail. Debt collector disclosure statement. Notice the agent is notice the principal. Notice the principal is notice the agent. Notice this document is not intended to threat, harass, hinder, or obstruct any lawful operation. It is for the purpose of attaining lawful remedy as is provided by law regarding their letters, the dates that they sent it, attorney letters, etc. Attention, write out their full name again. You can write out the attorney's name. Now, this can be used for credit cards, car loans, student loans, you name it, any type of loan. You can do this. Even if you have a lease on a vehicle, you should do this because leases are also securitized. This statement and answers contained herein may be used by your all uppercase name if necessary in any court of competent jurisdiction. Notice, this debt collector disclosure statement must be completed in accordance with the Fair Debt Collection Practices Act 15 U.S.C. 1692G and Title 8 of the Debt Collection Practices, Rosenthal Debt Collection Practices, which is the state of California, similar FDCPA. California Code Civil Codes, if those apply to you, 809 of the Federal Trade Commission's applicable portions of the Truth in Lending, Regulation Z, 12 CFR 226, and Rule 13A 15E under the Securities Act of 1934 as amended in the Exchange Act. Now, where did I get this? Well, I went into the REMIC and I read up on what their disclosures requirements are. So that was included, and I'm pretty sure most student loans are going to be the same. See, financial disclosures and accounting. And then this is a rule. And then you go look up that rule. Okay. So that's pertaining to the Securities Act. They know that you aren't looking that deep. All right. Commands as cited above, a dispute of alleged debt. Now entitle that the same title that we have here. Got to name it the same thing. So that's what we want to name it here. Okay, the debt collectors must make all required disclosures clearly and conspicuously in writing regarding the following. It goes through a list of questions, amount of the alleged, the account numbers, the debtor's address, the debt collector, name and address, date alleged debt became payable, name and address of original creditor if different from the alleged debt collector, which they should have, regarding the alleged account if the debt collector is different from the original creditor, does the debt collector have a bona fide affidavit of assignment to enter into the alleged original contract between the original creditor and alleged debtor? Now, remember, you're not calling yourself as a debtor, but these laws apply to consumers and debtors. You're just seeing who the debtor is. Did the alleged debt collector purchase the alleged account from the original creditors, yes or no? If applicable, on the date of the purchase, this alleged account from the original creditor and purchase amount. They must state it. Did the alleged debt collector purchase this alleged account from a previous debt collector, yes or no? If applicable, the date of the purchase of the alleged account from the previous debt collector, purchase and amount. Regarding the alleged account, did the debt collector, regarding this alleged account, is the debt collector currently the owner, B, assignee, or C, other? Explain. Has the debt collector provided the alleged debtor with the requisite verification of the alleged debt as required by the FDCPA and FFCPA? That's the Rosenthal Fair Debt Collection Practices Act for the state of California. And you can put it in whatever your state calls the Fair Debt Collection Practices Act. Was said verification cited in 13 in the form of sworn or affirm oath, affidavit, or deposition? Yes or no? Have any charge offs been made by the creditor or alleged debt collector regarding the alleged account? Have any insurance claim been made by the creditor or debt collector? Has there been a tax write-off and OID, 1099 OID? Have any tax deductions been made by the creditor regarding the alleged account? Has the statute of limitation expired for the debt? Provide the certified copies of the off-balance sheet transaction per the FAS 140, which we discussed. That's an off-balance sheet transaction. and 166 and 167, which is their amendments, Federal Reserve FR 2069, which are the balance sheets for the account, provide the SEC filing, including the reports 10K, 8K, 424B, the SIC number for the fund, and the CUSIP for the fund associated with the alleged account. If no SEC filing is available, then provide the CUSIP in the date of the transfer and Form S3 registration certificate. I was wrong. It's not S3A, it's S3. So Jerry Kane, you're also wrong. That's the date when they registered and transferred the note into the trust of the SEC filing. Debt collectors' failure, both intentional and otherwise, to complete and answer each point 1 through 20, I should put that 1 through 22 above and return this debt collector disclosure statement, as well as provide consumers authorization representative with a request verification validating the here and above referenced alleged debt constitute debt collector's tacit agreement that the debt collector has no verifiable lawful bona fide claim regarding the here and above referenced alleged account, and that the alleged debt collector tactically agrees that alleged debt collector waives all claims against the consumer and indemnifies and holds consumers harmless against any and all costs and fees heretofore and hereinafter incurred and related regarding any all collections attempts involving the here and above referenced alleged account. Now they have to sign it with an affidavit that they affirm or swear that the information is their first-hand knowledge and is true and accurate. It must be notarized when they give it back to you with all the documentation. And the rest of the information is a fair warning that they have 30 days to complete their responses. Okay? They can't give you misleading information or threaten to take legal action against you because you have a right to validate this debt, alleged debt. And this is also an additional notice to do not call, which could be part of the TCPA, Telephone Consumer Protection Act, which you should put your phone number into the Telephone Consumer Protection Act to do not call you. And if they do, then they will be charged a fee for that. So that's just their notice. Okay, and they have 30 days to respond as requested herein with a full and complete complete response. Okay, as requested herein with a full and complete response prohibits any further collection activities, including transfer or selling of this debt to successors and assigns. You sign and you date, and you can also put a notary affidavit or notary jurat or acknowledgement on this document. Now you do also need to have the green card return receipt so that you know that they picked it up and the clock starts clicking in 30 days. But when they get this, then they have to sign it under penalties of perjury before a notary, all the questions that you ask. Once you have the detail, you're telling them that you have some time that you need to review before you can settle this account. So once you know about the fraud, then you can offer to settle, which we talked about in the novation. Well, thank you very much, everybody. Hope you have a wonderful day. Bye-bye.